the Employment Act and its practicability, its practical application in our day-to-day engagements as HR practitioners. So, just wait a minute. Yes, I've already introduced my name, myself. So today we have a 3 hours program, and this presentation, this program will be doing a presentation, and we'll be discussing at the end of it all, where we'll be having a Q&A question and answer segment. And if you're to get your certificate, because after this program, you'll be able to get a certificate, but you'll only get the certificate if you have paid the 1,000 shillings. According to the flyer, I think you saw the flyer, and you'll be able to get your certificate through your login, through your account at achrp.org. Okay, I hope everybody has got their login. I know then at the end of this session will come and tell us how to get our certificates. So what's the course outline today? What's the objective of this training? At the end of this program, we want to be able to understand the Employment Act and the changes to the Act. Remember, we had an old Employment Act before the new one of 2007. So, but I believe it's been almost more than 10 years, right? So many people have got accustomed to the new Employment Act. So we will be discussing the practicability of the same. We'll also be able to establish the essential clauses and illegal terms of a contract. As an HR manager, it is important. We'll also be able to show the difference between a contract for service and a contract of service. We will also be able to know whether an employee's resignation can be rejected, okay? We will also be able to define misconduct. We'll be able to identify the difference between termination and dismissal, which is very, very important. We'll also be able to establish whether a change of employer breaks the continuity of a period of employment. And we'll also be able to see in what circumstances that kind of arrangement is broken, or when it is considered to still be subsistence in case of a break or of a change in employer. So we'll start right away, because before we start discussing the Employment Act, we have to be able to understand what a contract for service is and what a contract of service is. These two are different. And as we shall see, the reason we are starting with this is because the Employment Act only governs a contract of service. So we'll be able to establish the difference, and then we will get to know when a contract for service, when a contract of service is in place, which will be governed by the Employment Act that we are going to be discussing. So a contract for service is required when one wants to engage the services of a third party as an independent contractor for a specific project or a short-lived purpose. We can have examples of this. For example, when you want to construct your house, most times you will not have employees do it. You'll have like a private contractor who you give the plan for your house. Then they give you the requirements. They also tell you within which period of time they'll have finished constructing your house. This is a contract for service, and it is not governed by the Employment Act. It's not governed by the laws of employment in Kenya. It is governed by that specific contract. There are different terms in such contracts that are put in place. A contract of service, on the other hand, is a contract used in labor law to attribute rights and responsibilities between parties to a bargain. This is what we are dealing with today, because we are looking at the Employment Act. We want to understand what kind of contract is governed by this act, okay? And the contract of service will come into play when you have given this person, or the employer has given an employee the rights, okay? They've given this person work to do within a continuous period, and there's supervision needed for that person to be able to accomplish the work that they've been given. It is not okay, there are short-term contracts of service, which are also governed by employment law, but the employer must be directly or indirectly supervising the employee. That's the difference between this one and a contract for service, because a contract for service, you will not be directly supervising the person who is doing the work. In case you have a question, you can put it in the chat box, and then we will tackle those questions in the Q&A session later when we finish this presentation. So we are now moving on to contract of service, the different types of contracts of service. We have the permanent contracts. These ones are common in the government agencies, government organizations, where you see somebody is employed and they are on a permanent and pensionable type of employment. In most government organizations, though it has changed, I think this is now common in the national government, because recently we see the county governments, they give 5 years contract, and then after the 5 years, when the government changes, they employ different people, okay? In the national government is where we still have the permanent contracts, where people are employed until they retire or until they pass on. We also have a fixed term contract. These ones are common with NGOs and the county governments, where they give you a term of 1 year or 5 years, and after those 5 years, you are expected to exit the organization unless the contract has been renewed. We also have the casual contracts. These types of contracts are for people who work on a day-to-day basis and are paid on a daily or on a weekly basis. These types of contracts can also be attributed the rights and obligations as envisaged in the Employment Act. So it doesn't mean that just because somebody is working casually, it doesn't necessarily mean that they are not governed by the Employment Act. There are scenarios where somebody who is employed on a casual basis can still be attributed the rights and obligations as stated in the Employment Act. So these types of contracts are the ones that are governed by the Employment Act, and we're going to be going in details to see what terms and specific clauses you should have in your contract, okay? We were earlier on saying in the permanent employment, these contracts apply to employees who work regular hours and are paid a salary or hourly rate. The contracts are ongoing until terminated by either employee or employer, and may be for a full or a part-time work. We already went into detail of that. We have also discussed the fixed term contracts, which give a set date, for example, 6 months or 1 year. When the time expires, the contract automatically terminates. Casual contracts specify the minimum number of hours that you expect them to work each week, with the expectation being that the working pattern and hours offered above this minimum is likely to fluctuate. These ones are the ones where we commonly see people being paid overtime, and maybe they work on a shift basis, okay? Maybe somebody comes in for 8 hours from 8 to 4 in the evening, and then another shift comes in. We see mostly this occurring in industrialized type of organizations. So, under what circumstances can a casual contract be converted into an employment contract? If somebody works for a specific period or number of continuous working days which amount in aggregate to the equivalent of not less than 1 month. What does this mean? If somebody works for you, maybe you've given them a casual workers type of contract, and they work for 1 month continuously without a break, then it is converted into a contract of employment, okay? Another scenario is where somebody performs work which cannot reasonably be expected to be completed within a period or a number of working days, amounting in the aggregate to the equivalent of 3 months. The Employment Act is clear in the rules where it states that if somebody works for a period of 3 months, okay, an aggregate period of 3 months, and they are on a casual contract, you stand a likelihood of the contract being construed as a contract of employment. This is where I always say, always put your contracts in writing as HR managers. For example, if you're managing an industrial type of business, okay, if you're an HR manager for an industrialized type of business, most times you find scenarios where people just come sign a book. I think that has reduced because there have been so many cases in court that have emanated from such kinds of arrangements. So people have changed the way they do their casual workers and casual laborers contracts, okay? Long time ago, they used to just sign a book, and then at the end of 2 weeks, they are paid their weekly or daily rate. And then they work and continuously do that for a period of like 6 months. Some of them would even go up to a period of 3 years. And then at the end of the day, when their contract, when they're told there's no more work, they riot, they refuse to go home, and then they go to court, and the employer finds themselves paying a lot of money because there was never a contract in writing, okay? But these days, things have changed. People have embraced the new era of written contracts, because most times some people shy away. They're like, why should I write a contract? Then this person will come sue me at the end of the day. Another person will say, if I don't write a contract, then they will sue me, and you'll have nothing to prove that they are on a casual employment. So we are going to look at the essential terms of a contract. The essential terms of a contract are stipulated in Schedule number 2 of the Employment Act rules, which is commonly known as Legal Notice number 28 of 2014. These rules actually came in after 7 years of the Employment Act being enforced. And I believe the government realized that there are many things that hadn't been taken care of in the act that needed to be taken care of. So they now did a legal notice, and they incorporated some of these things, which we'll be discussing in the middle, because sometimes you're wondering, where do some people get some like where, for example, in the act is it provided for the specific terms of a contract? The act does not specify the terms of a contract, the essential terms of a contract, but if you look in the second schedule of the rules, that is Legal Notice number 28 of 2014, you will find that the contract must specify the name of the employer. It must specify the name of an employer. That is, if it's an individual or it's an organization, that should be specifically provided for in the contract. The contract of employment should also have a job description. What is the employee employed to do? So that at the end of the day, if they are assigned additional duty, if they come and claim for such monies, there is a basis. Because if you, for example, hired somebody to be a cleaner, and then you give them the duty of being a receptionist, they can actually claim double salary. Have you seen those scenarios where people claim double salary? They say, I was employed as a cleaner, but I was given the duties of being a receptionist as well, so I want to be paid for both. That is why the schedule specifically provides that you must have a job description for each employee that you have. Then the contract must also have the date of commencement of work. This is a very important aspect because it's useful in determining at the time of termination or dismissal how long this person has been working for the company. And it's also helpful in calculating things like gratuity, okay? So it's important to have a date of commencement. For example, some people are employed to start work on a later date than they get the appointment letters, okay? It also must stipulate the duration of the employment. Now, this is where it stipulates whether this person is on a permanent employment, or they are on a casual employment, or they are on a fixed term employment. For example, if you've been employed to work for 3 years, it's important for your contract to have that the contract will terminate after the expiry of 3 years, unless either party decides to renew it, and the same renewal should be asked for in writing. I think that's what most employers write in their contracts. The contract must also stipulate the place of work. Where is this person supposed to work? Okay, are they supposed to work in Nairobi? Are they supposed to work in Kisumu? Or are they supposed to work in Mombasa or Embu or maybe Busia or something? So it must stipulate where this person is supposed to work. Or maybe if they are a driver, are they going to be driving in the whole of Kenya, or are they only going to be driving only in Mombasa or something? In case they're working on a ship, are they going to be expected to work on a specific ship, or are they going to be changed from time to time, depending on which voyage the employer is taking at the moment? The contract must also stipulate the working hours, okay? Normally, you calculate the working hours according to the bare minimum that is provided for in the employment laws, okay? And this is important because in a case of overtime, how is it going to be calculated? Because we have to be able to know how many working hours this person was supposed to work. And if at all they worked more hours than they were supposed to work, what compensation plan is there for them? There's no other way to prove it unless the work has specifically, the working hours have specifically been provided for. Some people are expected to work for 3 hours in a day, and it is okay, and they are paid for that. So it is important, okay? Somebody should now not come and say, I used to work for 15 hours, because you didn't stipulate it in your contract. It will be hard for the employer to prove that this person actually did not work for 15 hours, as it was never stipulated in the contract. The contract must also provide for remuneration and the intervals of payment. For example, if a person is paid a daily rate, it must specifically say that the person will be paid a daily rate of 500 shillings. Let's say that's just an example, 500 shillings, and the same will be paid after 2 weeks or after a month. So at the end of the month, somebody is able to know, if I've not been paid by the end of the month, that means that the employer is owing me a particular amount, right? But if that is not stipulated, then somebody can go 3 months without being paid, and the contract didn't say anything about the intervals and the specific time the person is supposed to be paid. It didn't say any amount that the person is supposed to be paid. So it will be difficult for the employee to claim the salary that they are supposed to be paid. The contract must also indicate disciplinary rules and procedures applicable to employment. This is very important. I know most times in contracts, people shy away from making the contract long because they don't want to say all these things in the contract, and then they just direct the person and say there is at the end of the contract, they always put a clause that the person must abide by the rules of the of the organization, and they will be subjected to disciplinary rules according to whatever they put in the manual or whatever. It's important if you put it in your contract, because at the end of the day, somebody can say they did not get to see the manual, so they did not know the disciplinary procedure and all that. So it's very important for you to have it as a term of your contract, and the rules specifically provide for that. You leave it out at your own peril, because at the end of the day, it is you who has to prove in court that you actually provided this type of information to your employees, okay? So these are the specific terms that are supposed to be included in a contract according to the legal notice number 28 of 2014. We'll swiftly move on to tackle the Employment Act. The reason why we were doing this is because whatever we are going to discuss after now is specifically, it specifically covers the rules of engagement. It specifically covers what is supposed to be done when you have a contract of employment, okay? So we'll move on to the the Employment Act swiftly, and we have it arranged in different parts. We have the preliminaries, which talk about they have the definitions of things and establishment of very many things. We have general principles in the Employment Act. We have the employment relationship, when is it created? We have protection of wages, rights and duties of an employer and employee, termination and dismissal, protection of children, insolvency of employer, employment records, employment management, foreign contracts of service, dispute settlement procedure, and the miscellaneous. We also have the subsidiary legislation, which is now the legal notice number 28 that comes in. What do we mean by subsidiary legislation? These are the laws that come in to now govern the bigger act. For example, if we have the Employment Act, when you need to get to know how things are actually done practically, you go to the rules for you to be able to establish that. So we'll be tackling today the legal rights and duties of employees, because we've already established when does the employee-employer relationship come into force. It comes into force when somebody has been given a contract of service. So what are the legal rights and duties of employees? This is covered under Part 4, which provides for the basic minimum conditions of employment, okay? Provides for basic minimum. That means if at all you have terms that are worse than this, then you are considered not to be a good employer and you can be sued for that. So whatever you're going to discuss here is the bare minimum. If you have terms that are better than the bare minimum, then you have to follow those terms. You cannot now not go back and say the Employment Act provides for this, but I gave you a higher salary, so I'm going to reduce the salary and follow what is provided for in the Employment Act. No, if you give somebody a higher salary than what is provided for as the basic salary, bare minimum, you have to now follow what you gave this employee at the time of starting the employment. Section 26(2) of the Employment Act stipulates in case of a CBA or a contract with more favorable terms, the more favorable terms prevail over the basic minimum. That is exactly what I was saying. Section 27 now goes into, starts off the bare minimum principle, basic minimum principle of conditions of employment. Every employee is entitled to 1 day of rest in every period of 7 days. In most organizations, we see that people go to rest. Their rest day is usually on a Sunday, right? That is common in Africa. In the Arabic countries, we have Friday. Many people are off work on Friday. So depending on where your organization is set up, you have at least 1 day of rest, which can vary. Sometimes in the hotel industry, they always give the rest day on the less busiest days, because most times the weekends are very busy for the hotel industry. So what most of them do is that they give a rest day on either Monday or on a Wednesday. That is what I see commonly happening in the hotel industry. Section 28 stipulates that every employee is entitled to 21 working days leave with full pay after 12 months of consecutive service. This is what is commonly known as the annual leave. Every employee is entitled to 21 working days. 21 working days, that means Monday to Friday, okay? Monday to Friday, 21 of them. So when you, most times when you calculate it, it comes to almost a month. So many people always take off a month during a 12-month period. And this is only when somebody has served you for 12 consecutive months. That means somebody is not entitled to annual leave within the first year of employment. After the 1 year of successful employment, then they are entitled to leave in their second year of employment. Leave days can be divided in intervals. They don't have to be taken as a whole. Many organizations give that option of you dividing your leave. Maybe some people can take off 2 weeks at a time. Others can take off a week at a time, as long as by the end of the 12 months, you have taken off 21 working days. What happens in case somebody does not take leave? If an employee does not take leave, it means that the employer is supposed to pay them a salary in lieu of leave, 1 month's salary in lieu of leave. That is if somebody does not take their annual leave. So what happens to people who don't like to take leave? Because I know there are people who don't like to take leave. Even if you give them leave, they do not take leave. This is where we see the employer forcing somebody to take leave. They now go on a forced leave because it's stipulated in the law that they must rest for 1 month, for 21 working days in a year. If your employer does not give you leave, you can put it in writing and request for the leave. And if not, they have to pay you in lieu of leave. You cannot force somebody not to take their leave, okay? You cannot force somebody not to take their leave because it is stipulated under the Act. Section 29 says every female employee is entitled to 3 months maternity leave with full pay. It can be extended with the consent of the employer. Now, this right to maternity leave is only for female employees. And the Act, in the definition section, clearly states who a female is. According to the laws of Kenya, a female is somebody who was born female. At the time of birth, that person must have been a female. So if that person went and changed their gender by operation or whatever, the law does not recognize them as a female employee, and they will therefore not be entitled to maternity leave in case they give birth. I don't know if it is possible, but that's the position in the Kenyan law. So somebody who was born a female is considered to be a female according to the Employment Act. And if they give birth, they are entitled to 3 months maternity leave with full pay. You cannot deny them leave in case they give birth, okay? Even if it's a stillbirth, many times people ask, what if somebody had a stillbirth? Do they still qualify for leave? Yes, they do qualify for leave for the 3 months because the body needs to heal, the body needs to rest so that they can come back to work. Somebody else would ask, what happens in case of a miscarriage? Yeah, what happens in case of a miscarriage? It is also considered that that person is entitled to leave because, as the law provides, the person is entitled to have time to heal and also be ready to work, okay? After expiry of maternity leave, the employee has a right to return to the job she held previously or immediately prior to maternity leave, or to a reasonably suitable job on terms not less favorable. Sometimes you see people proceeding on maternity leave, and after they come back, they have been demoted. It happens in some organizations, or their salary has been cut, or they have now been replaced. Some people proceed on maternity leave, and then when their maternity leave is done, they are called and they are told that their work is no longer available. I've seen this happening a lot. Well, it's not agreeable by the Employment Act, because if you do that, that means you're being discriminatory on issues of sex, okay? What can happen in case you terminate somebody during their leave? You will be sued and you will pay them. You will be sued and you will pay them. I've even seen scenarios whereby if somebody is on leave, you cannot say you're doing an evaluation. On a maternity leave, you can't do an evaluation for the time they have been away on maternity leave. If you do that, you will be sued and you will pay as an employer. So if you have female employees, make sure you give them their maternity leave when it is due. And the Act stipulates that the leave can be extended with the consent of the employer. Maybe somebody did not heal on time and they need more time. The Act considers them and it says you can extend the leave. They can apply for an extension of leave and then they can be accorded the extension. The employee proceeding on maternity leave must give a notice at least of 7 days or a shorter period as may be reasonable. Of course, when somebody is pregnant as an employer, you automatically know there will be a time where they will give birth. However, the employee is given the obligation to notify the employer and say, I will be due during this time, I will be due around this time, so that the employer can have time to prepare for their absence. What happens if your employee gives birth on the day they are at work? What happens? That is why the Act now says, or a shorter period as may be reasonable. Some people want to work until the last day and you cannot force them to take leave because maybe they want to spend the exact 3 months with their newborn baby. So they can give you notice on that day, like, it's time. The person was at work and they tell you it's time. They now have to go because, it's nature. There's nothing they can do about it. No female shall forfeit their annual leave on account of taking maternity leave. We see sometimes in companies, some people asking if somebody has taken maternity leave, are they still entitled to annual leave? Yes, they are entitled to annual leave because annual leave is for every employee, while maternity leave is for only female employees that have children during a year, okay? So yes, they are entitled to their annual leave even if they give birth, even if they have taken maternity leave. A male employee is entitled to 2 weeks paternity leave with full pay, okay? A male employee is entitled to 2 weeks of paternity leave with full pay. What does this mean? If somebody has had a child, if the male employee has had a child, that is, if a woman has given birth, I am desisting from saying wife because some people are not married, but they have children. So if the male comes to you and says, my woman has given birth, they are entitled to 2 weeks paternity leave with full pay. The rules actually stipulate when this paternity leave is due. For example, if somebody has more than 2 wives or 2 women and they give birth during the same year, can they get leave 2 times in a year? The answer is no. This 2 weeks leave is for each year. Every 12 months, the male is expected to give birth once. Or if it is twice, that means they have to take 1 week for one baby and another week for another baby. A male employee cannot claim to take 2 weeks more than once in a year. That is what the rules say. So in case you are a male employee and you have more than 1 woman or more than 2 women, and they happen to be giving birth in the same year, you have to plan yourself and know for one baby you will take 1 week and the other baby you will take 1 week. Otherwise, your employer is not expected to give you 2 weeks for each child within 12 months, okay? And if you're an employer and somebody comes to you and takes 2 weeks, and then the same 12 months, they want to take another 2 weeks, you have the right to say no, because the rules specifically provide for that. 2 weeks within 1 year, just like of course, the female, it's automatic. You cannot give birth more than once in a year. It's not possible, okay? So yeah, that's it. We have a new aspect of leave that was introduced in 2022. There was an amendment to section 29, and there's an addition of an A, which provides for employees. Rather, an employee is entitled to 1 month pre-adoptive leave from the date of placement of a child in their care pursuant to a court order. What does this mean? In recent times, people have decided to adopt children. instead of giving birth, or even other people who have given birth decide to adopt additional children. So the drafters of the law found it fit for people who have adopted a child to spend time with that child, okay? This therefore means that they need, according to the drafters, they saw it fit for 1 month at least for this child to bond with the new parent. And this must only be accorded after a court order, because before you adopt a child, there is a process. There's a process that you go through. If you're into adoption, you know the process. If you would like to know the process, you can consult an advocate on the same. And there's a court order that the court issues before a child is placed in the care of the new parents. So this court order is always not immediately. They give time. That is why the law requires that you give 14 days of notice. As an employee, you give 14 days of notice to your employer so that they can be ready for the time you'll be away. What happens if two parents or two employees who want to adopt a child work in the same organization? Do you give leave to both of them? Of course, you give leave to both of them. You cannot discriminate them on this aspect. Though this now brings the question: what happens to the male? Do they get the 2 weeks or do they get the 1 month? In my thinking, they get the 1 month. This is still new. They've not yet brought rules to govern its practicability. So I hope in the days to come, we'll be having rules governing the practicability of this in line with the provisions of paternity and maternity leave. Section 30 of the Act stipulates that every employee is entitled to 7 days sick leave with full pay after 2 months of service. So if somebody has worked for you for at least 2 months and they fall sick, they are entitled to 7 days sick leave with full pay, okay? Excuse me. After the first 7 days, they are entitled to 7 more days with half pay within 1 year. This basically means that in case of a prolonged sickness, I've seen in recent times people tell me that their companies have policies that are more favorable than this. And as we said, if you have a contract that has more favorable terms, maybe you can give a month or even 2 months. We will go by what you have in your contract. The Act stipulates just the bare minimum of what should be considered, okay? Notice is required within reasonable time. In case you're sick, you have to notify your employer, because many times some people just assume that the employer knows that you're sick. No, it is the employee who is sick. So they must notify the employer within reasonable time, and they must provide medical documentation to support their sickness, because there are sometimes employees refuse to go to the doctor. They say, I am sick, but I will not go to the doctor. So how are you supposed to prove that you're sick without getting medical attention, you know? Okay, some sicknesses, they say cannot be explained, but I don't want to go in the detail of that. The law stipulates that you must show medical, you must show proof of sickness by showing documentation from certified medical assistants. Full pay means basic pay and excludes deductions, okay? What is the Act stipulating here? For example, if somebody goes on sick leave or in maternity leave, full pay only means the basic pay, because we'll be discussing further what payment and wages, salary and wages as stipulated in the Act. So we'll see what the basic pay is and why the full pay only includes basic pay. It cannot say that you must be paid full without deductions. No, you have to have the statutory deductions. Section 31 stipulates that employers shall at all times, at his own expense, provide reasonable housing, accommodation for his employees, or shall pay the employee such sufficient amount as rent. The Act stipulates that if you have employees, you must provide for them reasonable housing accommodation. Recently, we had a new debate. The housing, the national housing that the government is trying to do, where they want to now deduct a certain amount to go to the National Housing Fund, then people are expected to get those houses after some time. It's been a debate that has been happening in the recent 1 month, and people have really been apprehensive about it. I don't know if it goes against this provision of the law, because the law stipulates that the employer must give the employees reasonable housing. And if they don't give them reasonable housing, they shall pay the employees such amounts as sufficient to pay rent. Now, we see the government wants the employee to pay for their housing. They want to reduce the money of the employee, and I don't want to use force, and encourage the employee to get a house, okay, which they say they can decide to have in the future, continue paying for, or they can abandon. I don't know whether this, I think this goes against this provision. If you're in the HR, in the HR sector, as we are, most of us here, what do you think of that? Give us an opinion in the chat box and tell us what you think of that. In my opinion, it goes against the provision of Section 31 of the Employment Act, in my opinion, for people who are working in the government. In my opinion, a constitutional petition must be filed, in my opinion. But anyway, that is my opinion. Do not hold me by my words. So moving on swiftly, Part A says that this accommodation or housing can be provided for as a consolidated salary. What do we see happening in contracts? Most contracts will say you have been employed, do blah, blah work at this place, and you will be paid a consolidated salary of 100,000. So the consolidated salary is assumed to include the housing, okay? It is assumed that the consolidated salary includes the housing, it includes the rent, in case you've not been given the house itself, it includes the rent. Section 32 provides that employers must provide the employees with water, clean drinking water, okay? Clean drinking water is very important. Section 33 provides that provision of food is in cases where it has been expressly agreed at the time of entering the contract. So some companies or organizations decide to provide food for their employees. The Act has no problem with this, as long as you have specifically written it in your contract at the time of entering the contract, okay? Sometimes the company has a lot of money and they say, okay, let's buy lunch for our employees. And then employees now decide that they are entitled to lunch. If it was never part of the contract, then you are not entitled to that lunch. It is just out of the willingness and the good heart of your employer that they are actually giving you lunch or dinner or breakfast, or yeah, some employers give their employees lunch, breakfast, break tea, lunch, evening tea, and dinner. If it's in the employment contract, well, you can demand for it. If it's not in the employment contract, you cannot demand for it because it's not your right. Section 34 provides that employers shall ensure provision of sufficient and proper medicine for his employee during illness, and if possible, medical attention during serious illness. What does this mean? For example, if you are you have a workplace, most workplaces actually have like a nurse on the premises or a doctor to attend in cases of emergency. Now, the employer is expected to provide sufficient and proper medication. Okay? Section 34 continues to say the burden is upon the employer to know of the illness of the employee. Wow. This one, it's an interesting one, because if an employee is sick and he or she does not tell the employer, how is the employer supposed to know that the employee is sick? How? But the act is clear. The burden is upon the employer to know of the illness of the employee. So if your employee does not tell you, you now have to call their family and find out what is happening to this person. Why haven't they come to work? It's your burden. The act also continues to say the provision does not apply if the illness or injury was contracted during a period when the employee was absent from employment without lawful cause or excuse. For example, if somebody does not come to work and then they get an injury outside of work, you are not expected as an employee to, as an employer, to provide for their medication. What do employers do in order to make this easy for them? I see most employers have now taken out work injury insurance, okay, work injury insurance. And in case of such emergencies, they've provided employees with insurance cards. These emergencies are normally applicable to injuries that occur or sicknesses that occur during employment of an employee. Also, the employer is not expected to provide this medication if the illness or injury is proved to be self-inflicted. For example, if somebody harms themselves intentionally, it is not the fault of the employer that they did that. So they are not expected to provide for them a medication. This provision on medication also is not applicable if free treatment is being provided by the government. Now, most times you find employees going to the employer and they say, I was injured on this day, I was on your premises and I want you to take me to the most expensive hospital in Kenya. This is not logical, and the Act strictly provides that if free treatment is being provided for by the government for a particular kind of injury that happened during the time at work, you can send that employee to the government hospital. Okay, you can send them to the government hospital and they will be treated there if the government is offering free treatment. These days, we have an improved health system, considering the days in the past, whereby you can walk into a government hospital and you actually get treatment at free of charge, okay? We are continuing with the statutory benefits that are provided for in the Act. We have pension or retirement benefits for government organizations these days. I used to hear of pension a long time ago, but I guess even now they give them, is it called the golden envelope or brown envelope, to thank them for their service within the government. We also have national hospital and insurance fund deductions. Now, this is a benefit. I don't know why they are calling it a benefit, but it's actually a benefit in a way that you are deducted some money and then it is being put for you in a kitty. Then when you're sick, you can go to get treatment with this card. What has been happening these days? Monies are deducted, and then when people go to hospital, they are chased away. They are told that nobody is taking NHIF card these days. I've had very many people complaining that they go to hospital and NHIF does not pay their dues. okay? Yet money has been deducted from their salaries to cater for their medical emergencies. I think this is a failure on the part of the government, because if money has been deducted for a particular purpose, why then is somebody not able to get their treatment, yet a deduction was already done? Many people are being chased away by hospitals these days because NHIF is not paying the bills, so they are not getting treatment. This is really unfair. Though it is a statutory benefit, I don't think it's benefiting people these days. 2 years ago, I experienced a scenario where I had to undergo an operation and I did not have to pay a cent because NHIF came in and they paid. Unfortunately, it's happening now that people are unable to enjoy their benefit of NHIF. This needs an improvement, but as an employer, you are expected to deduct this NHIF and contribute it to on behalf of your employee, and also add something for them on top of that. We also have the statutory benefit of NSSF, National Social Security Fund deduction, which acts as a retirement benefit for the private sector. Now, this NSSF, I don't know how often people receive their monies. I've not yet retired. I hope when I retire, my money will still be there in the NSSF. I hope it will not have been used up like the NHIF is doing these days. In case you are in the HR department and you actually know of persons who have received their NSSF money, you can drop us a comment in the chat box so that we can share the experience with others. How is it done? How is it done? Because I always see, I think there's a difference between the NHIF and NSSF and the Pesayawaze. I normally see people lining up to pick their money. Is it the same with NSSF, or will they just deposit it in the bank account? Expatriates are exempted from NHIF and NSSF. Why is this? Because these are persons who have just come for a particular time in Kenya to conduct specific types of contracts or employment. And these are people who are not expected to retire in Kenya. So they are exempted according to the Act to this NHIF and NSSF. So we are looking at the rates, the new rates. There was a discussion to increase the rates, but according to the NHIF website, the rates have not been increased as well as yet, because this was increased sometime 1 month ago. So these are the prevailing rates at the moment. You will get time to go through them. The notes will be provided for on your SCHRP portal if you pay the requisite fee. If you've not yet been able to pay the fee, let me just remind you, if you've not been able to pay the fee for this program, kindly don't hesitate to pay after the program so that you can receive the notes and you can also receive your certification. NSSF rates at the moment is 12% of the worker's monthly pensionable income, that is the basic salary, of which 6% is contributed by the employee and 6% is contributed by the employer, both contributing an equal amount, with a maximum contribution of 2,160 for workers earning more than 18,000 per month. Okay, so there is a stipulation on the NSSF rate: 12%, 6% from the employer, 6% from the employee, if the worker is earning more than 18,000 per month. Well, there is on the NSSF portal, there is a provision for that as well. Taxation of employees. We now go to the taxation of employees, because as an HR manager, somebody will come and ask you, why have I not received my full pay? I worked for a month. Why is my money being deducted? Some people may know, some people may not know, but Payee is a method used to collect tax from residents and non-resident individuals from profitable employment. Profitable employment is where you are being paid or you are getting a remuneration in kind or in cash from your employment. Profits includes wages, salary, leave pay, sick pay, fees, commissions, bonuses, gratuity, traveling, and other allowances that employees receive from rendering service, okay? Pay is payable for employees earning a monthly income of 24,000 and must be remitted before each 9th day of each month. So as an HR manager, I know you may not be in charge of salaries and all, but it's important for you to understand this so that at the end of the day, when somebody complains that they did not receive the money the way they were supposed to receive it, you are able to explain to them that part of this went to the government on account of the payee. We have other benefits that are taxable. I've seen many people having a challenge with this because they say, if at all I've been given transport allowance, must that be also subjected to payee? Okay, so these are the non-cash benefits that are subject to payee according to the law. Vehicle or car benefit. If you give somebody a vehicle to use, the value of that vehicle is subjected to payee. The value of the fuel and whatever is subjected to payee. Provision of housing. If you are provided for a house, you are your house provision is subject to payee. That means when you're doing the payslip, we'll be looking at the slip later. So let me not go into that. We'll look at the payslip. Loans at interest rates lower than the market rates are also subject to pay. For example, if maybe you get a loan from your employer and the normal market rate is 14% per annum, and you're given a loan at 3% per annum, that means that loan is subjected to pay as well. Housing facilities such as water, electricity, telephone, security, and other expenses over 3,000 shillings per month are also subject to payee. Pension contributions paid by a tax-exempt employer to an unregistered plan over 20,000 per month is also subject to payee. Pension contribution paid by employers to a registered plan over 20,000 per month is also subject to payee. Employee benefits that are not chargeable under payee are as follows. We've already discussed what's chargeable under payee. We now have those that are not charged under payee. Medical cover by the employer is not subject to payee, okay? Pension contribution paid below 20,000 are not subject to payee. Amounts paid by the employer to reimburse expenses done by the employee for the company are not subject to payee. For example, if you used your money to do something and the company is now returning your money to you, if your microphone is on, kindly mute it, please. There's some interruption. Kindly mute your microphone. Thank you. Amounts paid by employer to reimburse expenses done by the employee for the company are not subject to payee. Amounts paid by an employer as gratuity or for registered pension scheme are not subject to payee. Education fees paid through employee income that the employer has already taxed is not subject to payee. The meals offered by the employer below 4,000 shillings per month is not subject to employees. So if you offer any meals above the 4,000 shillings per month, you are supposed to subject those meals to payee. Nights out of 2,000 per day are not subject to payee. So if you spend more than 2,000 on your employee in a day on a night out, then that amount, the excess is supposed to be subject to payee. Non-Kenyan citizens are expected, I beg your pardon, non-Kenyan citizens are exempted from payee taxes in conditions where they are in Kenya to serve an employer solely and on the passage between Kenya and the place outside Kenya. For example, if maybe we have a Tanzanian driver driving a truck through Kenya and maybe they are going to Congo, they are not expected to pay payee in case they are paid a salary when they are in Kenya. For example, if they are driving through, like maybe today is the 20th and then 30th finds them still in Kenya and they are paid by their employer who is in Tanzania or in Uganda, they are not expected to pay payee. All right. We now move on to supplementary employee benefits. These ones, you can choose to offer or not to offer them. These ones are not a must. They are just supplements. Educational assistance, mobile and internet allowance, life insurance, accidental insurance, identity theft protection, financial counseling, discounts on goods and service, workplace wellness programs, pick-up and drop-off facilities for employees, dependent care assistance, employee meals, dental insurance, bonus compensation. Now, these kinds of benefits are considered as supplements. If your employer is offering you any of these, it is not your right, it is just a supplement, and they are welcome to do it anytime and they are welcome to withdraw it anytime. You cannot force them to continue with it in case they want to withdraw. Now, we have the minimum wage. The minimum wage was not increased in May on Labor Day because everybody is always looking forward to Labor Day. No, the employees are always looking forward to Labor Day so that their salary can be increased. On the other hand, the employers are thinking, okay, after the salary has been increased, what next? Where am I going to get the money to pay the employees an increased salary? So we have the bare minimum wage, and this is according to last year's, okay? In 2022, that's when the bare minimum was increased, and the prevailing rates are as stated here below. The notes will be provided for. In case you do not have access to this, you can still go on the internet and you'll be able to get these rates. Make sure your contracts are in line with these rates. I will not go deep into them, but at least we can see there is a provision for Nairobi, Mombasa, Kisumu, and Nakuru cities. Those ones are the cities. Excuse me. Those are the cities. Then we have all former municipalities, town councils of Mavoko, Riru, and Limuru, and then we have all the other places, okay? We have all the other places that follow, that have their bare minimum. We now move on to part 4 of the Act that provides for salary payment. Salary can be paid in cash or by check or bank transfer, or can be paid to an authorized person. This is self-explanatory. You can pay the person in cash, whereby they have got to sign for the cash that you pay them. Otherwise, they will say you did not pay them. Checks are safe because you always have proof that you paid. Even the bank transfer is very safe because you always have proof that you paid the person their salary. Authorized person, now this is, for example, if somebody takes a loan and then authorizes that you can pay the bank, for example, if they take out a salary loan and then authorizes that you can pay the bank every month an amount of 5,000 shillings, the bank is considered to be an authorized person to receive the salary. If somebody takes out an insurance and then says that the insurance will be debited every month from their salary, the insurance company is considered to be an authorized person. If somebody has been sued in court and their salary has been attached, okay, by a court order, then the judgment holder, the decree holder, is considered to be an authorized person for purposes of payment of salary. If somebody has had a maintenance or child issues and they are sued, or there is a parental agreement and some money is supposed to go to their spouse or the mother or the father of their child in satisfaction of a court order or an agreement, that person is considered to be an authorized person to receive salary on behalf of the employee. So if money is paid in that line, that means you have actually paid the employee their salary, okay? We move on to the place and time of payment of salary. Where can you pay salary and when can you pay salary? You must pay salary on a working day. If your company works from Monday to Saturday, you must pay salary between Monday and Saturday. You cannot pay salary on Sunday if Sunday is not a working day, okay? The salary must be paid during working hours. If somebody works from 8 to 4, salary must be paid between 8 to 4. I don't know how practical this is in the day and age, because sometimes these days we see bank transfers that are being done in the middle of the night and it is still okay. I think those days it was very hard, but these days times have changed. Salary must be paid not in a place of intoxication or where liquor is being sold. The Act is trying to protect the employees because it knows that if somebody is paid probably in a club or in a liquor store, they'll probably use their salary to enjoy themselves, but the law is just trying to protect them. Or maybe that person may not even be able to know that they are being paid a salary in some instances. They may think you're just buying them drinks or you're giving them money to buy drinks. In case of payment in kind, where it has been agreed, okay? For example, sometimes you see companies maybe which are selling merchandise or land or whatever, they pay their employees in kind when it has been agreed. Somebody can say, I will take a television worth 20,000, okay? Or I will work for you for 1 year and then you'll give me half an acre of land. So if the person works for you for a year and you give them the acre of land, then that is considered to be a proper kind of payment, as long as it has been agreed upon by both parties. You cannot now say that you work for me and I'm giving you land, so I'm considering to have paid. It must have been agreed upon by both parties. When is salary paid? For casuals or casual workers, it's paid on a daily basis or as agreed by the parties, okay? For less than a month period at the end of the stipulated time. For example, somebody is working for 3 weeks, you can pay them salary at the end of the 3 weeks. It can also be paid at the end of each month in other cases. This is the common one, like every end of the month, people get paid their salary in most organizations. No payment during a period where the employee is serving a sentence of the court or is in prison. For example, if somebody is in prison, they cannot be paid a salary. Even if you owe them, maybe they went to prison today and you owe them a salary from last month, you cannot pay them their salary when they're still in prison. You have to wait for them to come out of prison and then you can pay them a salary. Or maybe they're serving another sentence of the court. You cannot consider to pay them a salary. You have to wait until they're out of there, then you can pay them a salary. Now, We are moving on to itemization and statutory deductions. Employer is to issue an itemized pay statement to the employee. When you pay your employee, you must issue them with an itemized pay statement, which is commonly known as the pay slip. Yeah, and this pay slip must include a basic salary. It must show all the statutory deductions. It must show overtime, if any. If somebody worked overtime, it must be included. It must show payment in lieu of leave in case that person did not take leave, and any other deductions. For example, maybe they are paying a loan or something. It must show all those things. Later, we'll be looking at the exact example of the payslip, okay? Now, we move on to termination and dismissal. We need to know the difference between termination and dismissal. Part 4 of the, Part 6 of the Employment Act states that a termination of contract can be automatic. If you have a contract for 3 months, at the lapse of the 3 months, it automatically terminates. Some people may not be able to understand this because they don't like to feel like they have no more work. Sometimes you have a contract, it is clear that the person is working for 1 year, but at the end of that 1 year, somebody doesn't want to go home. What do you do? What do you do? Don't continue to employ them just because they don't want to go home, okay? So in case the automatic, the period that the contract was stipulated for expires, that contract automatically terminates. When either of the parties cannot go on with the contract, it can also be terminated. For example, if there is a misconduct, okay? If there is a misconduct, you can terminate the contract, or you can, this is normally known as dismissal, all right? So if somebody does a misconduct during work, then they can be considered to be ripe for dismissal. When in cases of redundancy, a contract can terminate. Maybe the employer has no use for the employee anymore. They can declare the position redundant, and then the contract will be terminated. Acts of God, maybe death of an employer or death of an employee. The contract will automatically terminate because there will be nobody to be employed or nobody to employ the employee. It also can terminate in cases of illness. Maybe there is prolonged illness that cannot be expected to end soon. The contract can terminate as well. We had this act of God mostly in 2020 when we had the COVID-19. Many contracts were terminated because some companies closed completely. Some bosses died because many people actually died during that time. So we saw many people dying. And of course, when the boss dies, there's no more work for the employee. We saw employees dying. So when the employees die, you can consider that there's no more work. So the contracts were automatically terminated. In case the term has not come to an end, but one party wants to terminate, they must give notice as prescribed in the contract of employment or in accordance with the collective bargaining agreement, in case there is one. So in most contracts, as we discussed earlier on, we have a provision for termination. Even in a contract of maybe buying land or any other thing, you must have a termination clause. Okay, it's important as an HR manager, when you're doing your contracts, you must state how much time does somebody need to give as notice for the other to terminate. Okay, it's very, very important. If in some cases you have 4 months time, I see this mostly in the collective bargaining agreements. 4 months. They say if you want to terminate, you must give a notice of 4 months. Devoid of that, you must pay that person for the 4 months notice, okay? The normal stipulated time is 2 months, but if in case of a collective bargaining agreement where it says 4 months, or if there's a contract that says 4 months, then you must give notice of 4 months, whether you're the employer or the employee. In case you do not give the notice, then you must pay in lieu of notice. Where notice is not given as prescribed, either party has to pay in lieu of notice. How many times do we see employees paying employers in lieu of notice? Very few times, very, very, very few times. An employer has no right to decline the resignation of an employee, as it is tantamount to subjecting the employee to servitude, which is contrary to Article 30 of the Constitution of Kenya. Maybe you might have a question as an employer. If somebody comes and gives me a notice of 4 months or 3 months and tell me I am leaving at the end of the notice, can I refuse? I cannot refuse because it is their right. It's their right to terminate the contract as long as they do it according to the terms of the contract. If it is 2 months notice, they give me the 2 months notice, and I cannot say no. I cannot say no. All right? Even the same applies to the employee. If your employer gives you 2 months notice and tells you we'll be terminating you in 2 months, okay, maybe we no longer need you, you cannot refuse. You cannot refuse. Though we see a very difficult time, especially when you're trying to terminate an employee, they don't want to leave, and then they will do all sorts of things to ensure that they do not leave, okay? Now, we move on swiftly. Does change of an employer break continuity of a contract? Does change of an employer break the continuity of a contract? For example, if you're working on a contract, maybe you're on a
Failed to detect your speakers. Please make sure you know.
Kindly mute. Thank you. So under normal circumstances, if you change an employer, the continuity of a contract is broken, except in the circumstances below. If the business you work for is transferred to another employer, for example, maybe you're working in a hotel named ABC Hotel, and then ABC Hotel sells its shares to XYZ Hotel. Okay, that means the business has been transferred to XYZ Hotel. There'll be specific terms of engagement where
Have we lost Maureen?
I'm sorry, my electricity went off for a minute. Sorry, my electricity went off. But I'm now back. I hope you can hear me.
Yes, we can, Maureen.
Okay, thank you so much. My electricity went off for a minute, but it is now back. I'm so sorry about that. Yeah, so we're saying if the business is transferred to a new employer, then it is considered that that the employment has not broken. The contract has not broken. Most times we see they are specific about the terms of engagement. They'll say you will inherit all the debt, or you'll inherit all the employees that were working in that company before, you know. If one corporate body takes over another as your employer, you can have a continuity in the employment. If your employer dies and their personal representative keeps you in employment, for example, maybe you were working for a home and then the boss dies, then they do the succession and the children or the personal representative keeps you as an employee, then the term or the employment contract is not considered to be broken. When you move from one employer to another associated employer. Now, I beg your pardon. So when you move from one employer to as an associated employer, that means your contract is not considered to have been broken. If you are employed by one health service employer to another health service employer while under training, for example, you've been employed as a trainee, and then you are now moving on to another health service as a trainer, you can be considered to continue for your contract to have continued. Benefits in case of termination. We move on to benefits in cases of termination. Termination can be by either party. Remember, termination can be by either party, and we have specific benefits in cases of termination. If somebody is terminated properly, you know, when there are no issues on termination and everybody has agreed, they are entitled to specific things. One, they are entitled to service pay for every year worked, okay? Now, service pay is not applicable for persons in a pension fund for which the employer is contributing. Service pay is also not applicable in case of gratuity, of a gratuity fund or fund established by a CBA. It's also not applicable where employees are part of the National Social Security Fund, commonly known as the NSSF. You are not entitled to gratuity, I mean to service pay in case of termination. So, when can lawful termination occur? When can lawful termination occur? Lawful termination can occur in cases of a misconduct. What is a misconduct according to the Act? A misconduct occurs when any of the following are done. If you absent yourself without leave for a period as stipulated in the CBA or in the Act, okay? I mean, or your contract. For example, some companies have a policy: if you absent yourself for 1 week without leave and without permission, without saying anything, automatically you'll be terminated. Intoxication while on duty can also lead to termination because it is considered to be a misconduct. Negligence of duty can also amount to misconduct. Now here, it has to be proved that you did not do what you were supposed to do, and the company or your employer experienced a loss because you did not do what you were supposed to do. Use of abusive language at work can also be considered as a misconduct and can amount to termination. Refusing to obey lawful instructions can also amount to termination, as it is considered to be a misconduct. These instructions must be lawful, because if somebody tells you maybe to steal something on behalf of a company and you refuse, it cannot be considered a misconduct because it is not lawful to steal. Conviction in a court of law can also amount to termination. For example, if you've been accused of doing something against your employer, and then you are convicted by a court of law, you're found to be guilty, you are considered to be ripe for termination, and the employer is very, very, very free to terminate you if they wish. Now, what do we do when we want to terminate somebody? Before you terminate an employee, make sure you issue warnings in writing as an HR manager. This is important because it will go a long way to prove your case in court in case you proceed to court, or in case you go to the labor officer. You'll be able to prove that you actually issued warning letters and this person did not change. Well, for how long is a warning letter valid? In some organizations, a warning letter is valid for 3 months, while in some organizations, they say the warning letter is valid forever, depending on the kind of misconduct that somebody has committed. Issue notice to show cause in writing. For example, if you issue a warning letter and somebody does not change, you have to tell them again in writing, give them a notice to show cause why they should not be subjected to a disciplinary hearing. Remember, disciplinary hearing is an opportunity for somebody to be tabled with grievances, and then they can respond in their defense to those grievances of the company. Whatever accusation that may be there against them, they now have an opportunity to actually respond to it. When they respond to it, if they respond to the notice to show cause and they are subjected to have a disciplinary hearing, as an HR manager, make sure that you do an actual disciplinary hearing. What do I mean by this? It is considered that for somebody to have an actual disciplinary hearing, you must have the disciplinary committee sit on the specific date as stated in the notice to show cause, okay? Also make sure the employee comes with another employee of their choice, either as a witness or just to listen to the proceedings of that hearing. And after the hearing, when you do the minutes, make sure everybody signs the minutes before you make the decision to dismiss. What do we see happening in most organizations? They do the disciplinary hearing, the minutes are not signed by the person who attended the disciplinary hearing, and then they make a resolution to dismiss this person. By the time they want the person to sign the minutes, they've already dismissed them. We are human beings. That person will not sign the minutes. If you're not lucky, they will not sign the minutes, and at the end of the day, when you go to court, you will have no case. You cannot prove anything because it will be considered that first of all, they did not sign the minutes. So I will give you an advice that when you do the disciplinary hearing, make sure the employee signs the minutes before you make the decision to terminate. Most times, HR manager call for disciplinary hearings after they have already made the decision to terminate. And whatever is said in the disciplinary hearing does not matter because they already made the decision to terminate. So I advise that after the disciplinary hearing, make sure you do the minutes. Why do you have a secretary at the disciplinary hearing? These days, we have new technology whereby the minutes can be taken and typed during the hearing. So after the hearing, make sure everybody who was in the meeting actually signs the minutes. Otherwise, you will make a decision to terminate. You will terminate without signed minutes. And then when you go to court, the person or the employee who has been terminated will say they were never shown the minutes, they did not sign the minutes, and therefore do not agree with whatever is written in the minutes. That is where you see, most times when people go to court, they are asking, what does the court want me to do? I already did the hearing. Why is the court now telling me to pay, yet I already did the hearing? And this person, they refuse to sign. No, you now cannot prove that they refuse to sign, because it will be difficult in that case to prove it, okay? After the hearing, when the minutes have already been signed, give a recommendation of the hearing and its resolutions, okay? Maybe most times, by the time somebody is sent to disciplinary hearing, the company sometimes has already made the resolution to fire them or to terminate them. Most times it's like that. But it can be very harmful for the organization to do that. Make sure you give recommendations. What did the disciplinary hearing recommend? Now, the person who is attending the disciplinary hearing does not necessarily have to append a signature on the recommendations. They only have to append the signature on the minutes. After they've signed the minutes, then you can go and give a recommendation. Okay? And after giving the recommendation, you can either decide to maintain the employee, or you can decide to terminate, okay? After you have decided to terminate, in case you decide to terminate, put it in writing. Put the termination in writing. Tell the person, blah, 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 you start in a disciplinary hearing, you explained yourself, but the disciplinary committee was not satisfied with your explanation and has recommended a termination. We therefore terminate your service starting from this day. You have a right to appeal. Inform the employee in writing that they have a right to appeal, okay? In the same letter of dismissal, inform them of their right to appeal. If you do not do that, they can just come to court and say, yes, I was terminated, but I was not told of my right to appeal. Of course, in very few times do we find the court returning the employee who has been maybe terminated on account of misconduct after they've done a disciplinary hearing. But most times you find that the company ends up paying because of the laziness or the misinformation of the HR manager, because the job of the HR manager is to hire and fire, okay? Hire and fire. So if you've hired the right way, if you've incorporated everything we talked about in the contract, when it comes to termination, make sure you fire the right way. Otherwise, your organization will pay. Your organization will lose a lot of money because the HR manager was either too busy or too lazy to fire the right way, okay? So it's important to consider all that. What happens in case there's a dispute? In case somebody is terminated and they do not, they are not agreeing with the way they were terminated, what happens? You can either go to a trade union to solve the issue, okay? Or you can go to the labor officer, or you can go to the Employment and Labor Relations Court. These are all stipulated for in the Act. Dispute resolution. Now, in the trade union and the labor office, they always try to do an alternative dispute resolution kind of setup, whereby they prefer to speak to the employer and employees in either one setting or two different settings. And then after that, they can give the recommendations to either party. Now it's the parties to choose whether they want to follow those recommendations or they don't want to follow the recommendations. You can choose as an HR manager to finish the issues at the trade union level, or you can choose to actually proceed to the court. This we see mostly the employees are the ones who proceed to the court most of the time because they believe maybe the trade union has not calculated their dues or they've not done it correctly. So they believe mostly in the court to solve the issues, okay? So we are now going to delve slightly, or no, not slightly, deeply into the employment general rules of 2014, Employment General Rules of 2014, which is commonly known as Legal Notice number 28 of 2014. You're wondering, we already have the Employment Act. Why did they now come up with the rules? Why did they come back with the legal notice on employment? The rules are actually what makes the act practical. The rules stipulate those few things that were not stipulated in the act. For example, you're wondering, how am I supposed to do this? The rules are the ones that explains exactly how you're supposed to do it. And we will just be going slightly into them to see what they specifically provide. We'll start with the prohibition against forced labor. The rules stipulate that no employer shall subject an employee to work under undue threat or inhumane conditions or to any form of slavery. The rules actually provide that you cannot force somebody to work for you. That is why we earlier on said you cannot refuse somebody's resignation. If somebody wants to resign from work, you cannot force them to continue working for you, okay? It will be considered to be forced labor if you force somebody to continue working for you after you have resigned, after they have given you a resignation letter, okay? Rule number 4 stipulates that an employer shall put in place at every workplace policies, okay? You are wondering, where did employers get these work policies and disciplinary policies and sexual harassment policies? They get the mandate from the legal notice number 28, the Employment General Rules of 2014. So the policies that are put in place must first of all promote equality or opportunity in employment, in labor order, in employment, in order to eliminate discrimination in employment. The work policies must provide for equality, because the Act doesn't specifically provide for this. The rules came in to now say, when you are doing the employment policies, the work policies, you must promote equality and there must not be discrimination. The work policy must also provide equal opportunity, and this is provided for under Part B of Rule number 4, which states that the policies must promote and guarantee equal opportunity in employment for all employees, including migrant workers lawfully employed in Kenya. Maybe sometimes you can see policies saying the Kenyans, they are getting this specific treatment and the non-Kenyans are getting this specific treatment. That is wrong according to the rules. If somebody is lawfully here and they are an immigrant worker, they are entitled to the same opportunities as the Kenyans have been given. If your microphone is on, kindly mute so that we can continue properly. Rule 5 provides that in advertisement of an opportunity, a vacancy for a job shall be advertised in such a manner as to encourage application from suitable candidates, irrespective of their race, sex, color, language, religion, political or other opinion, nationality, ethnicity or social origin, disability, pregnancy, marital status, or HIV status. Okay? Sometimes people say, I only want to employ married people, or other people say, I don't employ married people. Other people say, I don't employ women because they'll be pregnant. We've seen such cases. We even see, even in the legal sector, where somebody puts out an advertisement, I am looking for a female advocate. Okay, yeah, I was in a forum on HR and they were discussing maybe some jobs are only suitable for men because they involve carrying heavy things, or they involve being away for a long time, for example, truck drivers and all that. Yes, but the rules specifically state that when you're advertising, you should not limit on account of these things, of race, of sex, religion, pregnancy, marital status, and all that. Okay. Rule number 6 stipulates that an employer who employs 12 or more employees shall, pursuant to Section 6 of the Act, issue a policy statement on sexual harassment in accordance with the guidelines set out in the first schedule. Okay, so if you do not know how to do your sexual harassment policy, or the policy against sexual harassment, I will recommend that you look at the second schedule of the rules of the legal notice number 28, so that you understand how a policy against sexual harassment is supposed to be drafted. There is a template there. You can go and look at it and draft your policy statement against sexual harassment if at all you have 12 or more employees at your workplace. An employee shall display the statement that the policy against sexual harassment. The statement shall be displayed, preferred, I beg your pardon, in a conspicuous place which is accessible to all employees. So you find a notice board that is accessible to all employees, you do this policy and you place it there, the policy against sexual harassment. Make sure you put it in a place that is accessible to all employees. Maybe you're wondering, where did these people get this sexual harassment policy from? They got it from the rules, okay? They got it from the rules. When we look at rule number 8 of the rules, it states that any employee on a contract of service exceeding 6 months, whose wages are paid at a monthly interval, shall be entitled to an itemized pay statement at or before the time at which any monthly payment or wages is made to that employee. This now brings us to this salary voucher, itemization of a person's salary. Any person who is paid on a monthly basis must have a salary voucher. And I've displayed for you what a salary voucher looks like. This is why you're wondering where I got it from. This is in line with schedule number 3 of the rules. It stipulates that this is how a salary voucher should look like. It should have the basic pay, the overtime, housing allowance, and bonuses. Remember, this here is the one that is subjected to payee. These things on the upper section and all the others that we discussed when we were discussing the issue of payee is what is subject to payee. These ones here, okay? These ones here. It also has to have the statutory deductions, which include payee, NSSF, NHIF, and in case of any union dues, you can deduct them as well. If you gave out an advance, you can deduct it as well. And if that person is paying a loan, you can deduct it as well. So this is a template of how your salary slip can look like. You can have more. You can have more information in the salary slip, okay? Now, rule number 9 stipulates that where an employer is required by the cabinet secretary to execute or deliver a bond under section 23 of the Act, the employer shall execute a bond in Form 2. Now, Form 2 provides how that bond is supposed to be executed, okay? Provides how that bond is supposed to be executed. There are some employers who are expected to execute a bond. For example, if you are giving security for employing foreigners, okay? There are some people who are employing foreigners, or they are employing children. We'll be discussing that issue of children, because most of you maybe are wondering, how can you talk about children when it comes to employment? We will also be discussing about it in the rules, because it provides for that. Some people are expected to sign a bond and deliver it to the cabinet secretary. It must be done within 30 days, okay? Maybe section 23 stipulates that if you are an employer and you're not incorporated in Kenya, or do not reside in Kenya. For example, somebody might be, a company might be incorporated in Uganda, but they have employees in Kenya. We see people who are working at the port. Maybe it's a clearing and forwarding company, and they reside, the company is registered in Uganda, okay? But they employ people at the port, and these people are Kenyans, okay? How sure is the government that this person will pay? What happens in case the Kenyans are not paid? You know, there will be a problem. So what the cabinet, what the laws require that they make a bond, there's like a security that they sign, and they give a guarantee to the government that they will be paying their workers. And in case they are not able to pay their workers, then there is some money that they deposit with the government, and the government will be able to pay the workers, because that, even if you sue that kind of company, they are not registered in Kenya. So you will have nothing, you will sue them, but you will not achieve anything from suing them, okay? Rule number 9.2 says, if the employer does not comply with the instructions of the cabinet secretary, they commit an offense, okay? But they must still pay the employee all the accrued wages, okay? I hope you understand that. If you don't understand, you can ask a question in the chat box, then we'll be able to answer it. The employer has the obligation to report the death of an employee to the labor officer in a Form 3 as provided for in the third schedule. For example, if somebody dies during employment or is your worker, you have an obligation to actually report the death of the employee, and there is a form provided for. If you go to schedule number 3 of the rules, you'll find a form. You're wondering, how can I report? You must report it to the labor officer in a form, and you indicate this person is no longer there. I have not projected the form on the computer, but if you go to the third schedule, you will see the form under which the death of an employee will be reported. It just has the name of the employee, the name of the employer, occupation, date of death, the cause of death, then the monthly earnings, if there are any that were still due, okay? Part 4 of the rules provide for paternity leave. That is where, when we were discussing the issue of paternity leave earlier, you were wondering where I'm getting these things from. A male employee is entitled to 2 weeks paternity leave and may take the leave at once or in a manner and on dates convenient to the employer and the employee, okay? Part 2 says, an application for paternity leave shall be accompanied by a sufficient evidence of the birth of a child in respect of whom the application is made. So somebody cannot just come and say, I am taking leave, paternity leave, because I have a child, and they provide no evidence. No, they must provide evidence that this child has been born. What do we have? When a child is born these days, you're given a birth notification. So as an employer, make sure you take a record of the birth notification before somebody proceeds. on maternity leave. Paternity leave. Paternity leave shall not exceed an aggregate of 2 weeks in 1 year. That is why earlier when I was telling you, if somebody has more than one woman and they give birth, they cannot take 2 weeks for one child and take another 2 weeks for another child. No, they must take 2 weeks in a year. So if you're a man and you know your women are about to give birth, you cannot take 2 weeks for the first one. Take 3 days, then take another 3 days. Okay, I'm not encouraging that, but I mean, we are in Africa, and if you're married under customary law, it is considered to be potentially polygamous. So this is providing for that element of potential polygamy in cases of traditional marriage. So yeah, you have only 2 weeks in a year to take paternity leave. Now, we move to this aspect in part 4 of the rules. You know, in the Employment Act, when you read the letters of the law, it seems to suggest that you can only employ people who are above the age of 18. But this is not the case. This is not the case. We see part 4 of the rules, and I find it very interesting. Part 4 of the rules actually says, no person shall employ a child who has not attained the age of 16 years. 16 years without prior written permission of an authorized officer. What does this suggest? This suggests that people of 16 years, between 16 and 17, can be employed. This is what the rules are suggesting. So when they are employed, how do they pay their tax? That is the question. How do they pay tax, or are they tax exempt? That's a big question. How practical is this? That is why this training is tagged the practicability of the Employment Act. How practical is this? If people below the age of 18 are employed, the Kenya Revenue Authority cannot collect tax from them because they have no tax PIN. But the rules here are saying no person shall employ a child who has not attained the age of 16 years without the prior written permission of an authorized officer. Okay? It goes on ahead to say that no person shall be permitted to employ a child first in circumstances that he or she will be away from the parents or guardians unless written permission has been granted. Wow. No person shall employ a child in a bar. That means if somebody is not yet 18, maybe they are 16, because you can see here the rules are suggesting that people of 16 years can be employed. So if somebody is not yet 18, they cannot be employed to work in a bar, hotel, restaurant, or club where intoxicating liquor is sold, or anywhere as a tourist guide. Okay? No person shall employ a child to perform any work which denies the child an opportunity to attend school, or to perform any work which substantially restricts the child's opportunity to play with other children. The rules are very clear on this. Okay? Now, the rules continue to say that employment of any child in any specified work to be performed as part of activities described in the first schedule shall be deemed to be harmful. So you cannot employ a child to do these things that are written here. There are very many. I will just highlight a few. When you go to the third schedule, to the fourth schedule of the rules, you will see that you cannot employ a child to do any of these because they are considered to be harmful to the health, safety, and morals of the child. For example, you can't employ a child to do housekeeping, food preparation, laundry, boda transport, serving as a porter, pushing a handcart, iyo mkokoteni, gang wars, bullfighting, ferrying of ammunition, underground digging, extraction. When you look at this, in short, you cannot employ this child because what are you employing them to do? What are you employing them to do? I think the drafters of the law, they realized that there are some people who are employing children who are below, who are 16, and there are some people who are employing children who are below the age of 16. So they are saying you cannot employ a child. A child, according to the Constitution, is any person below the age of 18. That person is considered to be a child. And now we have a very interesting scenario where they are saying you can employ somebody who is 16 and 17. I don't know how constitutional this is. I don't know how constitutional this is. I was in another forum where they were discussing, should we now let the child starve, yet they can pick bottles and then provide something for their family? You know, when they can sell milk and then provide something for their family. You know, it's a paradox. It's a paradox for me because in my thinking, the Constitution is clear. A child is somebody who is below the age of 18, okay, who has not yet attained the majority age. Majority age is the age of 18, but the rules are now saying you can employ a 16-year-old child. It's an interesting paradox. But when you look at the black and white of schedule number 4, in short, they're actually saying you cannot employ them. Because when you look at the Kenya we live in, these are most things that people would be wanting to employ a child. For example, brick making, carrying things, shoving sand, cement or soil, metal works, you know, mining. We see many children in the mining sector, in areas of the gold mines. They normally send the small children because they can fit in those small holes. It's not proper and it's against the law. You see, the things they are saying, sniffing crater powder, tanning and presuming hides and skins. It is illegal to use children as beggars, okay? Some people take their children to the street, or they actually employ children to go and beg, use the toddlers to ask for alms, okay? You cannot give them work to do with the work that is not unsanitary work is not allowed for children. You cannot use them to perform entertainment. They cannot be used in hospitality service, you know, things like that. And I even found another interesting one here. Glue sniffing. Who can employ a child to sniff glue? Like, honestly, maybe it was being done. That's why they had to put it in the rules. Maybe it was being done. We continue. Children between the age of 13 and 16 can be employed to do the following. First, it provided you cannot employ somebody who is below 16. Now it is providing children between the age of 13 and 16 can be employed to do the following. They can be employed as an apprentice or indentured learner in according with the Industrial Training Act. You see, sometimes maybe when children go to do hairdressing course and then they take them to the salons to try and do practice, you know, the industrial training. They can also be employed in accordance with schedule number 5. And schedule number 5 provides that the children between 13 and 16 can be employed to work for work performed at a school as part of the school curriculum for the benefit of the children. Now, earlier on in my practice, I encountered something very interesting. There was a school which was training children how to make bricks. Okay, they were doing bricks at the school, and it was part of the curriculum. And then they would pay them, I think, 50 shillings. I don't remember the amount, but there was a small amount they used to pay them. But during that time, one of the students got an accident and their hand was cut off. So now we were in court. We were in court, and the question was the school right in employing this child to do the bricks? Of course, it was part of the curriculum. It was a very, very interesting case. I remember it very well. So if they are performing work at the school as part of the school curriculum for the benefit of the child, you know, they are learning how to make bricks and all, but they are being given something very small to encourage them to do that. They used to do this on Saturdays. They can be employed in agricultural or horticultural activities, not exceeding 2 hours per day. Okay? They can also be employed to deliver non-bulky newspapers or printed material. Those are the children between 13 and 16. They can also be employed in a shop, okay, as attendants, and also including shelf stacking. They can also do domestic hairdressing, not commercial, domestic. They can also do light office work. They can also wash cars, car washing by hand, not by the pump, by hand in private residential setting. Sometimes maybe you tell your child, you wash for me in my car, I'll give you 20 bob to encourage them. This they say you can do in a private residential setting. They can work in a cafe or restaurant strictly to wait on tables, okay? Strictly to wait on tables. They cannot be involved in cooking and all that. So we move on. Rule number 13. Rule number 13 provides that a person who is authorized to employ more than 10 children below the age of 16 years on a permanent basis shall designate a person to be approved in writing by the Labor Commissioner to be responsible for the welfare of the children. This again is very, very interesting, because in as much as the law is saying you cannot employ children, it also provides, as they say, every general rule has got exceptions. So I believe these are the exceptions of the general rule. You cannot employ the children. But in case you want to employ the children, they have to be 16 and above. And in case you want to employ children that are below 16, that are between the age of 13 and 16, you have to have a permit. You have to have a permit, and then you have to have somebody in charge of their welfare. It's a very interesting paradox. I don't know how practical this is. And again, I said that is why this is about practicability. Is it practical as an employer to employ children? I don't get it. But anyway, it is the law. It is the law. I think they realized that children are actually being employed and they needed to be protected by the act. Because sometimes they say it is cheap labor for the employer. You know, cheap labor for the employer. That's what they say. A labor commissioner may delegate his power of approval under this rule to any other authorized officer. Okay? We are almost done. We now move on to medical certificates. No person shall employ a child in a ship other than a ship upon which only members of one family are employed, without the production of a medical certificate attesting to the fitness of the child for such work, signed by a registered medical practitioner. So they must show that the child is medically fit to work on a ship. Okay? This is interesting. And then that ship must only be a kind of ship that employs members of only one family. This is very, very interesting. I find it very interesting. I don't know how practical it is. The rule number 15 continues to say, a medical certificate issued in under rule 14 shall be valid for 1 year only, provided that the medical certificate which is due to expire during the course of voyage shall remain in force until the end of the voyage, okay? The continued employment of every child at sea shall be subject to the production each year of a further medical certificate attesting continuing fitness of the child for such work. A person who contravenes any provision of these parts commits an offense and shall be liable on conviction to a fine not exceeding 100,000 shillings or imprisonment for a term not exceeding 6 months or above. So if you are an employer and you contravene any of those things that we've talked about in line with employment of children, you will be liable on conviction to pay a fine of not more than 100,000, okay? Of not more than 100,000 or imprisonment for 6 months or both. You can pay both the fine and also be imprisoned. So we are moving on to the last aspect, sanitation. Now, this sanitation, I've tackled it briefly. And this is in line with the employers who provide housing for their employees. It is prescribed under the rules that you're supposed to provide a suitable latrine. For example, you find employers, this is practical in a setting that maybe you have 100 employees and then you're giving them housing. In their housing facility, you must give them provision for latrine at the ratio of 1 latrine per 12 persons, okay? And the latrines must be clean. Now, remember, this is the bare minimum. If you're giving the toilet, it is okay. You now don't have to go and change and give the latrine. No, you can give the toilet or the latrine. The latrine must have proof and must be leak proof. It must have a roof, sorry. It must have a roof and must be leak proof and should not have direct exposure to sunlight, to sunshine, not the sunlight. No, actually it's sunlight. It's sunlight. A latrine shall be constructed and roofed over as to be waterproof and to exclude direct sunlight. That is what the rules specifically provide. It also provides for provision of dustbins in their places of housing, okay? When they have when you've provided housing, then you must give them dustbins so that they can be able to dispose of their waste. It also provides that you must provide, the rules also provide that you must provide a sweeper, 1 or more sweepers, if a medical officer requires. This is for employers who provide employees with housing, okay? Now, rule number 26 stipulates that where any of the provisions in this part conflict with the provision of any bylaws or rules made under the Urban Areas and Cities Act of 2011, provision of these rules shall prevail, okay? Provision of these rules shall prevail over any other bylaws by cities and urban area development. Finally, we have part 4, part 6, which deals with the medical treatment of an employee. And rule number 26 says medical treatment of an employee shall be provided at the expense of the employer unless the illness or injury was contracted during any period when the employee was absent. Already we discussed that when we were talking about illness of an employee, okay? And if the illness is proved to be self-inflicted, the employer is not expected to provide medical attention. Or if medical treatment is provided free of charge by the government or any other insurance scheme established under any written law which covers the employee. For example, if they have the NHIF, they can go and be treated at that level, okay? We have the provision of medical treatments of first aid at the places of work. And then we have transport. This one we hadn't discussed it, where it is likely to be necessary for an employee to go to a hospital for medical treatment and some form of transport is necessary. The employer shall provide such transport as is reasonable, okay? On the discharge of the employee from hospital, if the medical officer is of the opinion that transport is necessary to take the employee back to the workplace or residence, the medical officer shall inform the employer to make arrangements for transport. And if the employer cannot be contacted, the medical officer may himself make such reasonable arrangement for transport of the employee at the expense of the employer. So in case the injury occurred at work, and then the person is taken to hospital, and then the ambulance needs to bring them back, or transport, they'll be organized for by the employer or the medical officer at the expense of the employer. An employer who fails to comply with any of the provisions of this part commits an offense and shall on conviction be liable to a fine not exceeding 10,000 shillings or to imprisonment for a term not exceeding 6 months or both. So in case you do not provide the latrine, in case you do not provide the medical expense, no, this is in line with the medical expense, sorry. In case you do not provide for medical treatment and you do not provide for your employee properly when they have been injured, you can be liable to a fine of 10,000 shillings or imprisonment for 6 months or both. The last part of these rules provide for foreign contracts. All foreign contracts of service under Section 83 of the Act shall be in the form set out in the schedule. That is the one that talks about the security bond. Maybe somebody is signing a contract with somebody in the US, they give the security bond, and then it will be subject to those rules. If you have a foreign contract, make sure your employer has signed a bond with the cabinet secretary. Otherwise, you may find yourself without being paid, and then you cannot run to anybody. No foreign contract of service shall be valid or enforceable against or in respect to an employee unless and until a medical certificate in form set out in 8th schedule has been given to the attesting officer in respect of that employee. That is enforcement of foreign contracts. And lastly, a person who fails to comply with any of these rules commits an offense and shall on conviction be liable except where a penalty is expressly provided to a fine not exceeding 50,000 shillings or to imprisonment for a term not exceeding 6 months or both. So in case you go against the rules that we've just read, the ones in line with the children, the ones in line with the provision of sanitary equipment and latrines, the one in line with the leave, if you are convicted, you will pay a fine of 50,000 or be imprisoned for 6 months or both. That is if a specific amount of money has not been provided for. For example, the one for children was 100,000. So if it has been expressly provided for the 100,000, you will now pay the 100,000 instead of the 50,000 that has been said. Okay. So I'll invite all of you to delve into the rules. If you do not know where to find the rules, you can find them on the kenyalaw.org. You can download them and then you can familiarize with them so that you're not caught on the wrong side of the law. I hope you have enjoyed my presentation. I hope you've enjoyed my presentation. I would now invite the Q&A segment. We have about 35 minutes for this. I'll go to the chat box and see from the time we started. I think I missed some, I'm missing some chats. I'm missing some chats from here because my phone, I mean, my electricity went off at some time, at some moment there in the presentation. Let us see. Somebody is asking a question. Kindly put more clarification on what to pay when terminated due to misconduct, gross misconduct. We will look at provisions of section 44 of the Act. Just give me a moment so that we go to that. So it will clearly tell you what you're supposed to pay. Okay? When you have actually terminated somebody for misconduct, we'll just go and look at that shortly. Just a moment. As I look for that, let me look at the other. Where the contract of employment provides for 3 months notice upon termination, how do you handle this during redundancy? Should the employee serve the notice 3 months? Do you still pay the 1 month redundancy notice? Now, redundancy is governed by completely different rules. Let me try to. Just a minute. I'm trying to, because redundancy and termination are very different. They are very different. They do not have the same rules. Just wait a minute. Let me answer this question about gross misconduct. If you terminate somebody because of gross misconduct, we are looking at section number 44 of the Act. If you terminate somebody on account of gross misconduct, you will just pay them their dues, okay? You will just pay them their dues, because if it is a lawful one, they do not have to, they are not entitled to any other thing, because if it's a lawful termination, it's lawful. You do not have to pay them anything in addition. But in case there's an unfair termination, then they are entitled to additional payment, okay? In case of unfair termination, that is when they are entitled to a different payment, and that would include wages which the employee would have earned had the employee been given the period of notice. That is when you pay the notice period, okay? If the termination is unfair. That is according to section number 49 of the Employment Act, where dismissal terminates the contract before the completion of any service upon the employee's wage became due, the proportion of the wage due. Like, for example, if you terminated in the middle of the month, you pay them for what they had worked. An equivalent of the number of months' wage or salary not exceeding 12 months based on the gross monthly wage. So if you have terminated properly, you don't need to pay anything else. You just pay for the notice and whatever they were demanding from the company. But if it's unfair, that's when you now have to give them 12 months payment if you're found to have terminated them unfairly. Mary is asking, where a contract of employment provides for 3 months notice upon termination, how do you handle this during the redundancy? Redundancy is governed by different rules altogether. Let me just point that out for you. Redundancy, sorry, not redundancy, redundancy. It's very different from the normal termination. Just wait 1 minute. So if at all you have terminated somebody on account of redundancy, you now have to pay them for a severance pay. When you have termination on account of redundancy, that's where the severance pay comes in, and it's not less than 15 days pay for each complete year of service. So you must pay them the severance pay if you have declared them redundant. Is the opinion of labor officer in adhere exercise binding? The labor officer is just there to help people resolve a matter. Actually, no, in adhere, the only decision that is binding is the arbitration process. If people have agreed to do an alternative dispute resolution through an arbitrator and they've both agreed to that, that is the only one that is binding. Anything mediation is not binding. You can refuse it. You can refuse the mediation and say you are not satisfied, and then you go on to the higher judicial system. You go to the judicial system and have it solved. When there is an agreement with a casual staff to pay on a monthly basis, are they entitled to a salary or wage voucher? No, they are not entitled to a salary and wage voucher. Wait a minute. Yes, they are. Yes, they are. They are, because you have to pay for them payee. You have to pay for them payee. That is why it is important for you to have a contract that specifies the terms, because everyone is entitled, whether they are on casual basis, they are entitled to a salary voucher. That will help inform them of their payee, of their monthly deductions, and all that we had discussed before. Birth notification does not indicate details of the father. How does it act as proof? Is there another document that can be used? Is there another document that can be used? Birth notification. The birth notification is given at the hospital level. I don't think the chiefs now give out the birth notification. Which other document can be used instead of the birth notification? Well, sometimes people refuse to indicate the names of their fathers, and there's nothing we can do about it. There's nothing we can do about it. There's nothing we can do about it. But for somebody to have a birth notification of a child, that should necessarily mean that, okay, it cannot necessarily be construed that that person is the father. I wouldn't think there would be a reason why somebody would want to take paternity leave for a child that's not theirs. What if it's given as evidence of proof of paternity? Let me do more research about that, Dorcas, on the issue of birth notification. Is there a timeline for application for paternity leave? The Act and the rules have not stipulated for the time within which the paternity leave must be applied for, because the Act just says you have to give leave, and the rules don't show. They don't show they don't provide. They actually don't provide for the time limit within which a paternity leave must be taken. It does not show. It doesn't show. Samuel is saying, is the DP right to say employment is for stakeholders? Well, I will not answer that. I will not answer that, Samuel. The screen is not moving, it's stuck on sanitation. Oh, sorry, Julia. Sorry, Julia. I did not read the message before that. Sorry. Share slides, please. You are on sanitation, provide latrine ratio 1:2. Okay, sorry. I'll they will be in the notes. They'll be in the notes. Thank you for that. Let me just take that down. The screen on sanitation. Okay. Thank you so much. Sorry, I was not reading there. Thank you. Well presented. Thank you, Agne. Good presentation. Thank you. If the employee provides the notice for 1 month resignation at the end of the month, are they supposed to pay the severance pay on the final dues? Now, the notice of resignation is supposed to be 1 month. When they give you a notice, it doesn't mean it's immediate. It's not immediate. The notice means they are going to work for the coming month, okay? They'll be working for the coming month. That is why it's a 1 month notice. It doesn't mean that if it's 30th and you give it on 30th, then it's deemed to take effect. No, the resignation is supposed to take effect after the term of the notice. It is not immediate. So if they do not give the notice period, if they do not serve the notice period, that means they are expected to pay the employer for the notice not served. What steps should the HR take when the employee refuses to present show cause letter? I beg your pardon. What steps should the HR take when an employee refuses to present show cause letter? Maybe Tabitha, maybe you can rephrase your question, because the HR is the one that issues the notice to show cause letter, right? The HR manager issues the notice to show cause to the employee. That is the position, right? So how can the employee refuse to present show cause letter? Or are you saying to respond? If they do not respond to the show cause letter, or if they do not respond to the show cause letter, then you invite them to the disciplinary hearing and tell them that you gave them a notice to show cause letter. They have not responded within the stipulated time, okay? They should then come for a disciplinary hearing. Actually, in essence, if you give a notice to show cause, The next step should be a response, okay? The response from the person. If the response does not satisfy the HR manager, they now call for disciplinary. Many times, HR managers just do the notice to show cause and the disciplinary at the same time, because you are telling somebody to tell you the reason why they should not be taken for the disciplinary action, and you're already taking them to the disciplinary action. In my opinion, it is wrong. It should be a step-by-step process. Notice to show cause, then there is a response. In case of no response, you call the person to the disciplinary hearing. You schedule one. In case there is a response, you consider the response and then say, we have considered the response of the letter dated this. However, we feel like you should be subjected to the disciplinary hearing. Kindly appear before us on this date with an employee of your choice and answer the following accusations. You see, so it shouldn't be a notice to show cause at the same time an invitation to disciplinary hearing. It is not correct to do it that way. Most people like to do the shortcut and they just say, I gave him a notice to show cause and invited him to a disciplinary hearing. That way, in my opinion, the court will consider that in you sending a notice to show cause, you already intended to put this person to a disciplinary hearing. So it doesn't matter what they respond to you in the notice to show cause, you had already made up your mind that they are going for disciplinary hearing. Because if they are able to explain themselves in the letter, why then would they have a disciplinary hearing? It doesn't make sense. Do we have a legal retirement age? Well, if you're working for the government, of course, because it was reduced the other day. It was reduced the other day. Growing up, people were expected to retire at the age of 65. I think there were less people who were employed then. These days, the retirement age has been reduced. They've been reduced to the age of 60. Before it was 65, now it is 60. And then you can also retire early at the age of 50, because in some companies, they choose to retire their people early, okay? They chose to retire the people early, but in other instances, we have people working until the age of 65. There are those who can retire at 50. Others can retire at 55, okay? And for people with disabilities, they can go until 65. People with disabilities can go until 65. Okay? Let's move on to the next one. Sorry, I had it the other way around. Before it was 55, then it was taken to 60, and people with disabilities can even retire at 65. But you can also retire early. Early retirement is at 50. Is the extra income on pay slip supposed to be taxed? What do you mean by extra income? What do you mean by extra income? The overtime? Let me share with you the slide on the salary slip. Juliet, let me share with you the salary slip. You see, this is how it looks like. Basic pay is taxable. Overtime pay is taxable. Is that what you're calling the extra income? If this is what you call extra income, then yes, it is taxable. Housing allowance is taxable. Bonus, oh, I think you could be referring to as the bonus. Bonus is also taxable. Car allowance is taxable. Loans that are less than the prevailing market rate is also taxable. So yes, extra income is taxable. Any other benefits like water, security, phone benefit that are above the amount of 3,000 per month is also taxable, okay? No, 4,000. Any food provided above 4,000 is also taxable. Any night out given to an employee above 2,000 per day is also taxable. So yeah, extra income is taxable. It is taxable. Paternity leave, do we count calendar days or working days? They just said 2 weeks. They just said 2 weeks. In the rules and in the act, they say 2 weeks. But in the spirit of the law, it should be working days in the spirit of the law. Because the rules say paternity leave shall not exceed an aggregate of 2 weeks in any 1 year. That is what the rules provide. So it provides for 2 weeks, just like maternity leave. Maternity leave, you don't count working days. Maternity leave, you count calendar days. So paternity leave is also calendar days. The only one that is counted working days is the annual leave, which is 21 working days. What happens when an employee refuses to sign a contract claiming of a higher increment as to what was offered? Wait, what happens when an employee refuses to sign a contract claiming of a higher increment as to what was offered? Or if they want more money, than what is provided for in the contract and they refuse to sign, then they have no contract. They cannot work without a contract. They cannot work without a contract. If they refuse to sign, then they have no contract. Then they shouldn't work because they refuse to sign. They cannot force it. The employment relationship is a double-sided relationship. It is not single-sided. So yes, if they refuse to sign the contract, then they should not work. They cannot force the employer to pay them what they cannot afford, and unless it is below the bare minimum. If it is above the bare minimum, the employer cannot be forced to pay more than what they are offering, okay? Catherine is saying, comment on constructive dismissal. Constructive dismissal is it occurs when an employee resigns because their employer's behavior has become so intolerable or made life so difficult that the employee has no choice but to resign. Yes, there are some employers who make life difficult for their employees. And remember, an employment relationship is a willing employer, willing employee. So if somebody is frustrating you at employment, these days, it is better if you resign, because if you cannot work properly, why are you working? So yes, Catherine says constructive dismissal. Of course, notice must be given, reasons must be given. Somebody has to write and say, I am leaving because you have frustrated my efforts. I cannot be able to do my work. So I am unable to work, and therefore I don't think I can stay in this place, okay? Oh yeah, Tabitha was saying if somebody refuses to reply to a notice to show cause letter, if they refuse to reply, then you have to put it. That is why I say, Tabitha, you must follow the steps. Don't give a notice to show cause letter and also include an invitation to disciplinary hearing, because that way it will spoil the chronology of events. That way you will not say that you gave a chance to this person. You already invited them to a hearing before you could actually hear their reason. You know, a notice to show cause It's a notice to show cause why you should not be subjected to a disciplinary hearing or subjected to disciplinary action. Let the person respond. If they fail to respond within reasonable time or the time that is provided for by the letter, you can now say, we gave you a letter on this day, you did not respond to the letter, so come for the disciplinary hearing. You know, that is in my thinking. So yeah, it should be chronological so that it saves you that, you know, there's a reason why people used to say that the employment court is for employees. It was said like that because people were not following the chronology of events. People were always in a rush to fire employees, and they're saying this one did something wrong, so I must fire them. Give them an opportunity, give them a show cause, let them respond. If they don't respond, give them a notice to come and attend disciplinary hearing. Sometimes the issue can be solved at the notice to show cause level. Maybe you are saying you refuse to do this and this, and then the person actually shows cause and says, I was not in a position to do this and this because I did not have the cleaning equipment. So if you actually assess the situation and you actually find that they did not have the cleaning equipment, then it can be resolved at that level. What happens if contract ends and the employee goes on and they are paid salary? Jen is asking a question. If an employee's contract ends and then they continue working and you pay them a salary, you have continued their contract by conduct. If an employee's contract ends, they are supposed to stop working. If they don't stop working and you also entertain it, it is considered that you have continued their employment by conduct. Okay? You are supposed to give them a letter and tell them your contract ended. Why are you still coming to work? If you continue to entertain them, then you will end up paying them. The question on redundancy was on notice. If contract has favorable terms, 3 months notice, should the employer pay 3 months plus 1 month redundancy notice equaling 4? Yes, Mary. Yes, that is the position. Or 3 months only. No, you have to include the redundancy because redundancy is considered that somebody is no longer able to earn what they were expecting to earn. So yeah. Is it in order to engage casuals for 90 days contract, give a break, then rearrange, or should the engagement be entirely under 1 month? It should be entirely under 1 month, Phyllis. For your own safety, it should be under 1 month. If you're giving 30 days contract, 90 days contract, let it be 90 days contract. But if you give the 90 days contract, you must give them all the rights that they are entitled to under the employment law, okay? So you cannot just say they are here for 3 months and then you rearrange. No, it has to be under 1 month. Internship agreements, where do they fall on the contract type? Do they pay tax? Internship agreements, interns, they pay tax because those are, no, but interns don't have the employee relationship. They do not have I will have to do more research on the internship agreement, and then internship agreements. I'm writing that down because I haven't faced a case where an intern is claiming some money from from their pupil master, from their master. Okay, I see them. Oh, yeah. The Employment Act talks about discrimination on politics views. Yes, it does. A retirement age used to be 55. Yes, it was 55. Thank you for that. Samuel, it was 55, then it went to 60. Then for people living with disabilities, it is at 65. How long should an employee be away on interdiction, and how long should the investigation take? Well, Joan, that depends on the company. That depends on the company or organization, because different organizations have different ways of doing things. But normally, I've seen government organizations sending somebody for 6 months on interdiction. Sometimes they send for 6 months. So depending on the organization and how it does its investigation, the law has not provided for that. How do I convince the employer to pay the final dues to an employee summarily dismissed on allegation of involvement in fraudulent activities? The case is with the police, but the ex-employee hasn't been charged, hence still assumed innocent. Now, if they have been charged if they've not yet been charged, well, that is interesting. You cannot fire them. You cannot fire them if they've not been charged. Actually, that's the question they will be asking in court. Was I charged? Was I charged for the offense? So they need to be charged before they are paid their final dues. Okay, they need to be charged before they are paid their final dues, because how are you paying them their final dues and it's not yet even been determined whether your dismissal was actually a true reflection of a correct dismissal? If the employer needs, they can actually go to court on a civil claim on fraudulent activity and then have the court decide the matter. But I've seen people who have been charged, who have been dismissed on account of fraudulent activity. When we normally go to court, from experience, the question normally is, has the person been charged? If they've not been charged with an offense, then it may be a little bit difficult, okay? Is gratuity taxable? Is gratuity taxable? No, I don't think gratuity is taxable. In my opinion, I haven't seen a case where they've taxed gratuity, because gratuity, when you are paying gratuity, that is for a service. Wait a minute, let me just check. Let me not give you the wrong thing. Let me just check. Is gratuity taxable? Yeah, the KRA is saying that they are taxing the gratuity. KRA says they tax the gratuity. Yeah, gratuity is taxable. Gratuity is taxable, according to KRA. Should you tax allowances not offered in a monthly pay? Case example, allowances given to an employee to perform an assignment outside their job post. All types of allowances are taxable, except refunds, except reimbursements. All allowances are taxable. All allowances are taxable according to KRA. It has been very informative presentation. I enjoyed it, Alice. Thank you so much, Alice. Various contracts different between independent contracts and short-term. Difference between independent contract and I don't get that. I don't get that, Catherine. We have 3 minutes to go. If I've not been able to answer your question, I'm sorry, because now I have to give an opportunity to ACHRP, then to give a comment. I don't know if he's on the platform, and also tell you more about how to get your certification for this program. Then back to you, if you are on the platform. Thank you, Dan.
Thank you, Maureen. Thank you for taking us through this particular training on the Employment Act and its practical applications. Today is 20th May, the Human Resource World Day in the world. Therefore, we thought that it would be very important for us to visit or revisit the issues of employment law. The employment law is what anchors everything we do as HR professionals. It creates that engagement between the employer and the employees, and where we find ourselves as HR professionals in the middle, trying to be the go-between between the employer and the employees. Sometimes when things go wrong, we find ourselves having a case to answer. I was reading a document that is this particular case on doctrine on constructive dismissal. Doctrine of constructive dismissal. Maybe if I go to the beginning, this is case number 237 and 239 of 2019 in the Labor and Employment Court. This particular case was adjudicated by Justice Rika. In this particular case, there was that question by Catherine regarding constructive dismissal. Number one, constructive dismissal refers to a situation in which the employer employer's behavior towards an employee is so severe and intolerable that it leaves the employee with no choice other than to resign. Now, these two cases, number 237 and 239, they were later consolidated. And what was happening here? The employer decided to stop payment of salary, because the issue, when I go through this, it is that the employer at some point decided to stop the salary of these employees with no reason at all. I'll share this in your portal. This is a course number 337, sorry, and 339, and the year is 2011. It should have been a little bit clear on that one. This was at the Employment and Labor Relations Court at Nairobi. The judge was James Rika. And sometimes it is important as HR professionals to be going to the Kenya Law website. There are so many cases regarding employment. This was between Kenneth Borough and another versus Kibe Muigai Holdings Limited. And by the end of the day, let's see what the judgment and what they say here on number 7, because the claimants sought what they wanted the court to rule was were they constructively dismissed? The respondent suggested in its response that the claimants performed their roles poorly and were dismissed for gross misconduct. And so eventually, the court says constructive dismissal is not defined in our Employment Act of 2007. The concept was the subject of this court award in cause number 611 of 2009 between Maria Kagai Ligaga versus Coca-Cola East Central Africa Limited. The court found that constructive dismissal occurs where an employee is forced to leave his job against his will because of his employer's conduct. At that point, you already see where you will be able to find where we are being told that in the Employment Act 2007, constructive dismissal is not defined. But again, the last training, Pauline told us that when it comes to labor laws, sometimes past rulings form part of what we would expect a certain legal issue to proceed, because the judges those in the litigation are guided by what happened in the past. That this is because of his employer's conduct. Although there is no actual dismissal, the treatment is sufficiently bad that the employee regards himself as having been unfairly dismissed. The basic ingredients in constructive dismissal are: A, the employer must be in breach of the contract of employment. And B, the breach must be fundamental as to be considered a reparatory breach. And C, the employee must resign in response to that breach. And D, the employee must not delay in resigning after the breach has taken place. Otherwise, the court may find the breach waived. And that is very interesting, that the employee must not delay. In the Ligaga award, the claimant was transferred from Kenya to Uganda. They transferred to Kenya, then to Mozambique, all within a very short notice. She was never allowed to settle in any position or market, and was finally repatriated to Kenya and moved from one town to the other at considerable disruption to her family life. She resigned, and the court found resignation was involuntary and amounted to constructive dismissal. The claimant was granted monetary compensation. The award has since been appealed against the Kenya Court of Appeal. I guess by now it has been ruled. Maureen, you get us that and share so that I will be able also to fix this together. Now, in this particular case, the one I was referring to, these of 337 and 339 of 2021, the conduct of by the employer. Now, these were the findings by the court. The respondent failed to pay the claimants the July, August, September, and part of October 2020 salary. Then eventually, having reached these findings, the court grants the respective claims in the following terms. One, the claimants were employees of the respondents and were constructively dismissed. Kenneth Kimanimboro, first claimant, shall be paid by the respondents 1 month salary in lieu of notice. His salary, by the way, was 280,000 per month. Then salary for July, August, September 2010 that is 840. Salary for 7 days worked in October, 75,000. 5 months salary in damages for unfair constructive dismissal, 1.4. Total 2.5. Then on side, these were 2 people. Again, the same is repeated, and the amount to be paid was there. The total amount was 3.6. Shall be paid by the respondents to the claimants within 40 days of the delivery of this award. The advocates to agree on an ICT professional to examine. But here is the issue of, my point is, which I've already shared, is that constructive dismissal is always there, especially where the employee feels mistreated to a point of resigning. They want to leave their work because the employer's behavior is so intolerable. And I'm glad to see you, Mr. Olesi. Now, Mr. Olesi is a trainer, a lecturer on labor and employment issues. He lectures at the Presbyterian University. Dr. Olesi, welcome. And I hope that you will share with us something very soon. Now, we'll continue having these trainings on labor laws, because from our various WhatsApp groups, we have 30 of those. Most of them are full to capacity with the 10, 20, let me see. Nowadays, groups have a capacity of 1,025 people. So most of them are full, but we would be able to have space. If you're not in any of our groups, kindly text me on WhatsApp at 0722 300 245. I've shared that number there. Now, for all who are registered for this particular training, log into your portal. I had shared that previously. That is at our website is achlp.org. You can write that down. This has not changed. Our website has not changed for the last 7 years since we started doing this. achlp.org. And your password at all times when you want to log in is HR2021. That makes the work easier, or the work easy for everyone. HR2021. Once you are logged in, go to My Courses. Go to My Courses. Once you are logged in, you'll go to My Courses. You'll find this particular course, that is the Employment Act and its practical applications. The display on that page is in a table format. That table has headings. The column, that table has columns, and those columns have got headings. Now, on the heading titled Presentations, you'll click View Notes. And with that, you are able to view your presentation. I noted at the beginning, somebody had said that, okay, the trainer was a little bit fast, but I remember later on the trainer was able to go at our pace. Now, this training, remember, this training was recorded. We recorded the training so that for future reference, you will be able to view the entire recording since the training began. Let me show you how the display for the labels for the display for our portal looks like. So when I say you'll go to our website, our website looks like that. This is ACHLP. At the top there, you can see achlp.org. And anytime you go to the website, the first page you see is the, on the left-hand side, there is the photo display showing our various physical trainings. And on the left side, there is a login form. So on the login form, let me log in with my account. On the login form, and you'll always see that the password is indicated there, HR2021. We had to do this because people kept forgetting. People kept forgetting this password. So I had to put it there. But remember, you have to type it, HR2021, small letters. If you're using your own laptop, you could say, remember me. Then click login. And once you log in, the website has got only, not the website. Once logged in, there are only 5 menus, or rather 5 pages there. The Take Courses, the My Courses, My Certifications, where your name appears. And mostly, if you've not completed the details on your profile, when you log in, it will take you to this page, requiring you to complete the details, everything. Why do we want everything there? Because your certificate will always take your full name. The details on your invoice, or rather your receipt, your certificate, they are being pulled from this portal. Now, in a situation where you are self-employed, that part of organizational details, repeat the details from the personal details, like organizational name, don't say not applicable, otherwise you will get a receipt titled not applicable. You'd rather have your full name repeated at the organization name. Then that part for organizational email, repeat your personal email. That way, you'll get a receipt or rather an invoice that has clearer details. But now, for purposes of this training, we say, assuming I had taken this course, don't think I have, but let's see. This is course number 11. And the easiest way to enroll for our programs, for those who are already in this portal, when you log in, you will add on the Take Courses page. You scroll down to the course in question. On the first column, there are check boxes. Check the box for the course which you are interested in. Then scroll up to the beginning of the table above the years, 2017, 2018, 2020, and so on. The amount payable for that training will be indicated there. Then the M-Pesa pay bill number is indicated there. Then the account number is indicated there. Remember, with Lipa na M-Pesa, add the account number. You can't copy this particular account number now because the account number varies depending on who has logged into the account and on what course they have selected. So assuming, let me pay for this course, and I think I have, and that is my M-Pesa code. So I'll have to type this M-Pesa code, or rather this transaction code there. We leave this here so that for those who've paid through bank, they're able to type that transaction code there. And once that it has been typed there, you click submit. Now, for those who've enrolled, you might have found that under my courses, sometimes the way I read this system, I do it in vernacular. That way, I'm able to take courses like in a supermarket. Those are courses I have not taken, that are not mine. Then once I've bought them, they become my courses. I find them on this page showing my courses. So Dr. Olesi, you'll be able to find your course number 5, or it might be number 1, depending on the number of courses you have. But if it is already approved, and let me approve this now for, I may need to approve this for purposes of this training. May need to approve this for just a moment. I'm approving this on the admin side. So, assuming this is my courses, and you've already taken the Employment Act and its practical applications, under the presentations column, you'll go to View Now. There we are. I'm able to, this is what happens when you are not done with completing your organization details, but you are able to see the notes. Those are the notes. You're able to go to next page, and so on. These are the notes which the trainer was taking us through. All of them are here. You're able to go through the notes at your own pace. Sometimes when you become tired, you could jump to number 58, that part for question and answer. And you could still go to previous page. So a total of 58 pages are in this presentation, but you might not be interested in reading the notes. Therefore, you may want to go to the video link. So you just click on the left side, there is a video link, and you are able to click open. Now here is the video for the entire training. So there we go. You can hear the trainer.
These ones are common in the government agencies, government organizations, where you see somebody is employed and they are on a permanent and pensionable type of employment. And in most government organizations, though it has changed, I think this is now common in the national government, because recently we see the county government, we give 5 years contract.
So point is, next time never miss our training because you are not able to attend. You usually record all our trainings and you're able to access them in your portal. You're also able to access your certificate from your portal again. And that makes work easier for all of us in that portal, you'll go to my courses once again. And by 4 p.m. today, the column headed certificate, that is the second last column. Right now it would be showing pending, but the system is set in a way that by 4 p.m. they should be able to release your certificate. But you can be able to view, you can also be able to download the certificate. If in your portal, under my courses, you find your courses already preloaded, you've not paid for them, it is easy. Just click pay now and you proceed. You go ahead to make, you go ahead and process your payment. You can actually receive an M-Pesa prompt on your phone by clicking said M-Pesa prompt. If you had paid to our previous pay bill, you just enter that transaction code there and submit. If you had paid via bank, again, you do the same. You click that, the reference number there. So it becomes very easy to navigate this system. And if you don't want to undertake any activity, you can log out. And once you log out, it returns you back to the default mode at achlp.org, where you will be supposed to log in again to access the system. Thank you. Let's not take a lot of time. I want to wish you all the best this morning at the later part of the day, unless one has a question. Dr. Olesi, you want to say something?
Just want to say that I've enjoyed the forum and I wish to interact with the many of us and many more forums to come.
Yes.
Yeah.
I'll create a topic for you.
Okay.
Our programs mostly are 3-hour programs.